Hello friends, and welcome back to our channel. If you're a serious UPSC aspirant, you know that every part of the Constitution is crucial. Today, we are diving deep into a section that often raises a lot of questions, but is absolutely vital for both prelims and mains, Part 16. So, grab your notebooks, and let's get started. Part 16 of the Indian Constitution is titled Special Provisions Relating to Certain Classes. It spans from Article 332 to Article 342. The core idea behind this part is to provide a framework for the social, economic, and political upliftment of specific sections of society that have faced historical disadvantages. These classes are primarily the scheduled castes, or SCS, the scheduled tribes, or STS, and the Anglo-Indian community. Later, provisions for the socially and educationally backward classes, or SEBCs, were also included. Let's break it down, article by article, to understand its nuances. We begin with the political safeguards. Article 330 is the first one, and it deals with the reservation of seats for scheduled castes and scheduled tribes in the House of the People, which is our Sabha. It mandates that seats shall be reserved for SES and STS in the Sabha. The number of seats reserved in any state or union territory is determined based on the proportion of their population to the total population of that state. This ensures that these communities have a voice in the highest legislative body of the country. Following this, Article 331 originally dealt with a representation of the Anglo-Indian community in the Lok Sabha. It empowered the president to nominate not more than 2 members of the Anglo-Indian community if they felt the community was not adequately represented. However, it's very important to note a recent development here. The 104th Constitutional Amendment Act of 2019 has discontinued this provision. So, as of now, the nomination of Anglo-Indians to the Lok Sabha has ceased. This is a key update for your exam. Next up is Article 332, which mirrors Article 330, but at the state level, it provides for the reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states, just like in the Lok Sabha. The number of reserved seats is proportional to their population in that particular state. This ensures their representation in state-level governance and policy-making. Similarly, Article 333 was the state-level counterpart to Article 331. It allowed the governor of a state to nominate 1 member of the Anglo-Indian community to the state legislative assembly if the community was not adequately represented. But again, just like the provision for the Lok Sabha, the 104th Amendment has also discontinued this provision for state assemblies. So, no more nominations for Anglo-Indians at the state level either. Now, a crucial point about these reservations is their duration. Article 334 originally stated that these reservations and special representations would cease after 10 years from the commencement of the Constitution. However, this period has been extended successively by various constitutional amendments. The 104th Amendment, while discontinuing the Anglo-Indian nominations, extended the reservation for SES and STS in the Lok Sabha and state assemblies for another 10 years, up to January 25, 2030. This periodic extension is a recurring theme and a hot topic for analysis. Moving on from political representation, Part 16 also addresses claims to services and posts. Article 335 is a very balanced and often debated article. It states that the claims of the members of the scheduled castes and scheduled tribes shall be taken into consideration, consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the union or of a state. This means that while affirmative action is necessary, it should not compromise administrative efficiency. A proviso was later added, which allows for relaxing qualifying marks or lowering standards of evaluation for reservation in promotions for SCS and STS. This article highlights the delicate balance the Constitution seeks to achieve between social justice and meritocracy. Next, Article 336 dealt with special provisions for the Anglo-Indian community in certain services, like railways, customs, and postal services. It provided for reservations for them for a limited period after the Constitution came into effect. This was a transitional provision, and it is no longer in operation. Similarly, Article 337 provided for special financial grants for the benefit of the Anglo-Indian community in respect of education. This too was a temporary provision for 10 years and is now obsolete. Now, let's talk about the institutional framework that Part 16 establishes. This is where we get into the commissions. Article 338 is extremely important. It provides for a National Commission for Scheduled Castes, or NCSC. Originally, the Constitution provided for a special officer for SCS and STS. Later, a multi-member commission was set up. The 89th Constitutional Amendment Act of 2003 bifurcated the combined National Commission for SCS and STS into two separate bodies. The NCSC is now a constitutional body tasked with investigating and monitoring all matters relating to the safeguards provided for the inquiring into specific complaints, and advising on the planning process of their socioeconomic development. Its reports are presented to the President, who lays them before Parliament. Following the bifurcation, we have Article 338, which created the National Commission for Scheduled Tribes, or NC. Its functions and powers are similar to the NCSC, but its focus is exclusively on the welfare, protection, and development of the scheduled tribes. The creation of a separate commission recognized the unique and distinct challenges faced by tribal communities, which are often different from those of the scheduled castes. Then comes a more recent addition, Article 338. This was inserted by the 102nd Constitutional Amendment Act in 2018, which conferred constitutional status upon the National Commission for Backward Classes, or NCBC. Before this amendment, the NCBC was a statutory body. Now, it has powers on par with the NCSC and NCST. Its mandate is to examine complaints and welfare, measures regarding the socially and educationally backward classes. This amendment significantly strengthened the institutional mechanism for protecting the rights of OBC. So, to recap the commissions, Article 338, 4, 338A for NCST, and 338B for NCBC. All are powerful constitutional bodies. Now, let's look at the administrative aspect. Article 339 deals with the control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. It empowers the President to appoint a commission to report on the administration of scheduled areas and the welfare of STS in the states. It also gives the Union executive the power to give directions to a state as to the drawing up and execution of schemes, specified in the direction to be essential for the welfare of the STS in the state. Article 340 is the source of the famous Mandel Commission. It empowers the President to appoint a commission to investigate the conditions of socially and educationally backward classes and the difficulties under which they labor, and to make recommendations to remove such difficulties. The Kaka-Kalelka Commission in the 1950s and the B.P. Mandel Commission in the 1970s were appointed under this very article. The recommendations of the Mandel Commission eventually led to the implementation of reservations for OBC. Finally, we come to the definitions. Who are the scheduled castes and scheduled tribes? Articles 341 and 342 answer this. Article 341 empowers the President to specify the castes, races, or tribes which shall be deemed to be scheduled castes in relation to a particular state or union territory. Once this list is notified by the President, any inclusion or exclusion from this list can only be done by an act of Parliament, not by a subsequent presidential notification. This is a crucial detail for prelims. The President specifies the list, but only Parliament can amend it. Similarly, Article 342 gives the President the power to specify the tribes or tribal communities which shall be deemed to be scheduled tribes in relation to a state or union territory. And just like with the SC list, any modification to the Saint list can only be done by Parliament. Also, remember, Article 366 of the Constitution provides the definitions. Article 366-24 defines scheduled castes as such: castes, races, or tribes, specified as SCS, under Article 341. So, that's a comprehensive overview of Part 16. It is the constitutional bedrock of India's affirmative action policies. It provides for political representation, safeguards in public employment, and dedicated commissions to protect and promote the interests of the SCS, STS, and OBC. For your UPSC preparation, understanding not just the articles, but also the constitutional amendments that have shaped this part, is absolutely essential. The 89th, 102 a day, and 104th amendments are particularly significant. In recent times, I hope this detailed breakdown was helpful. Understanding Part 16 is not just about memorizing articles. It's about appreciating the constitutional vision for a more inclusive and equitable India. If you have any questions, drop them in the comments below. We'll try our best to answer them. Thanks for watching, and don't forget to like, share, and subscribe for more deep dives into the Indian Constitution. See you in the next video.